Hello, today I'm going to discuss the case of Corey Beanty Melton versus the state of Alabama, a computer forensics case study. This case doesn't have as much information about the investigation process regarding the types of tools used by the forensic investigators, but overall it does have some good information regarding the gray areas, specifically in legal matters that investigators may come up against. In 2005, Corey Beanty Melton was having trouble with his personal computer. He was unable to connect to the internet consistently. He took it to Best Buy to have the Geek Squad troubleshoot and repair any issues identified. Initially, while Mr. Melton was still in the store, the Geek Squad determined that there may be a problem with the DVD drive, but they wanted to do some further diagnostics, and so Melton left his computer with the technicians. When he left the computer, he also filled out an information sheet with contact information, including his address, his name, and his phone number. While the investigators were running the diagnostics, they determined that the computer had a virus. So they started their process of removing a virus. Nothing out of the ordinary. Once they deleted the virus from the computer, they would go to reboot the computer and the virus would attach itself again to a particular set of files. In investigating the virus, they came upon these files, and the files were named with explicit names that were suggestive of child pornography. The technicians contacted law enforcement regarding the files, as their policy had dictated, the company policy. There is some discrepancy on whether the technicians opened the files or not. In the court case, the technicians stated that they did open the file and started viewing the video briefly, but then stopped it immediately once they saw the content and contacted law enforcement. Mr. Melton states that, as far as he's concerned, the technicians never opened the file, even though they've testified in a court of law that they did. The police investigation, detectives arrived at the store and asked the technician to open the illicit content. They specifically only had them open the file that they had viewed initially. The file did contain a video of child pornography. Once the investigator saw that, he requested that the employee put the computer back together, at which point they took possession of the computer. Additionally, they requested the information that Mr. Melton had filled out when he brought the computer to the store so that they could contact him directly. Again, at that time, this is important, the investigator only reviewed the file that the technicians discovered. A search warrant was subsequently obtained to search the entire computer. At the police department, once they had the computer in their possession, as well as a warrant to search the remaining contents of the computer, the detective called in a special agent to perform the forensic examination. Again, I didn't go into much detail as far as the actual tools used. The examiner did testify that his examination indicated the computer belonged to Melton and was used regularly because he found common files such as a resume, personal pictures, etc. He also testified that he found numerous videos containing child pornography, and many of them were at least 15 minutes long. Based on the findings, the agent testified that in his experience, the videos could not have been caused by pop-ups. This is important because one of the arguments that Melton was providing as to why he had the content in his computer was that he used the computer in a network sharing scenario, and that he was alluding to the fact that perhaps someone else had gone to a website and the virus was causing these pop-ups, inappropriate files to be on the computer. Again, the important part about this investigator the content was already discovered, and Mr. Melton had made no attempt to hide the content or save it as a different file in order to prevent people from looking at it or even use passcodes on the files. So the examination itself wasn't having to go through and identify some of these files that may have been modified, but really to determine that it was Melton's computer, and then rule out the possibility of any other causes other than Milton downloading and being in possession of the videos. Again, the initial defense, Melton testified that it was his computer tower and that he did take the computer to Best Buy for repair. He also stated that he had purchased the computer on eBay and it was a custom build. According to Melton, the computer was mainly purchased for business use, that he and his friends were starting a new business. He confirmed that to his knowledge and recollection, the computer had no files, videos, or information on it. That itself ruled out the possibility of the illicit material being on the computer before he had it in his possession. He also stated that several people had access to the computer through a peer-to-peer sharing network and that he never downloaded files that contained pornography. He did testify that he clicked on a video once, and once he saw the contents of the video, he deleted the file immediately. This particular piece of information right here would be the supporting piece of information that the forensics investigator was able to refute the idea that it was a pop-up, that maybe he clicked on a video one time and from that point forward he continued to receive these pop-up messages, or that's where the virus had come from. So the forensic investigator was able to rule out any possibility of mistakenly saving a file. He also stated that he had never seen the video the state presented as evidence. And that's Mr. Melton. Melton was convicted by a trial court of possession of obscene matter, a violation of Alabama Code, and he was sentenced to prison for 10 years. He appealed his ruling in 2010. And this is where it gets interesting as far as an investigator, a computer forensics investigator, and some of the legal challenges that have to be navigated through. The appeal went to the Court of Criminal Appeals of Alabama. Melton's appeal essentially stated that his Fourth Amendment rights were violated. He alleged that unlawful search and seizure occurred when the investigators viewed the file at Best Buy and confiscated the computer. And he also argued that the state did not prove venue, since the investigation originated at the Best Buy, which is in a different county than the county he resided in. The Fourth Amendment basically guarantees the right of people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. Shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. In other words, the police cannot search you or your property without a warrant or probable cause. Melton argued in front of the Court of Appeals that his Fourth Amendment rights were violated when the investigators arrived at Best Buy. Essentially, he states that the employees at Best Buy had not opened any files. Their testimony refutes that. Before law enforcement arrived, therefore they had no right to open the files without a warrant. Melton uses the premise that law enforcement would not have known the contents of the file had they not opened it, and there was no alleged crime until they viewed the movie. Ultimately, he argued that the right to privacy or guarantee against unlawful search and seizure was violated because there was no warrant issued when law enforcement viewed the file and no probable cause that a crime had been committed. The state of Alabama argued that once Melton turned his computer over to Best Buy to have the technicians repair his files, he relinquished reasonable expectation of his right to privacy. Additionally, Melton did not specify any files that were off limits to the Best Buy technicians, nor did he have the passwords on any of the files that contained child pornography. Therefore, privacy and the foundations of the Fourth Amendment were not violated. Additionally, the file names were labeled with terms that strongly suggest the appearance of child pornography, including common terms that one may search on the internet if trying to locate child pornography. And the state of Alabama also concluded that because of the file names, the state argued that society would consider that reasonable cause enough to open the file due to the illicit naming of the file. In the final decision, the Court of Appeals upheld the original charges and sentencing of Corey Bean T. Melton. The court determined that Melton gave up any right to privacy once he voluntarily gave his computer to the Geek Squad and gave them permission to remove the virus from his computer. Takeaways from a computer forensic standpoint. The most interesting piece of the investigation and appeal is the idea that because the files were named with explicit names that suggested child pornography, law enforcement was able to view the file and subsequently obtain a warrant to perform a forensic investigation on the entire hard drive. Had Melton named the files something different, then they may not have been discovered, and reasonable cause would not have been upheld in the courts. While there are few details provided about the forensic investigation, the entire process is useful when discussing computer forensics as a whole and the legal challenges investigators face. Additionally, a third party initially discovered the illegal material and reported it to authorities. The crime could have easily gone undetected if the technicians at Best Buy decided to ignore the files and simply repair the computer. On the issue of venue for Mr. Melton, he argued that the county that he lived in, which is the county in which the computer was kept, was Jefferson County, and that the Best Buy was in another county, border county, and so the investigators were actually from the county that the Best Buy is in and not the county in which the property normally stayed, and that was thrown out pretty easily by the state of Alabama. Again, I think the main points here, the idea that the investigators were very cautious from the beginning. They only had the technicians open the specific file that they had already viewed. If they would have had the technicians open any other files while they were there without a warrant, that would have been considered unlawful search. They did wait to investigate the remaining parts of the computer until after they received the warrant to do so. And additionally, the whole idea of the file names has kind of been a precedent of sorts, simply because the way the files were named is what tipped off the technicians that there may be illegal material, which is what got the ball rolling to begin with. And had Mr. Melton simply named the file something different, then they would have had no reason to suspect any sort of crime or criminal activity on the computer. For this case study, I mainly referred to the court document for Melton versus the state of Alabama, and that was from the Alabama Court of Appeals in 2010. And then there was an article on Forbes in 2010 that put the court document into layman's terms as far as giving what happened and what the outcome was. Mrs. Hill definitely harps on in her article on Forbes about the file name issue, and that for future studies that would be upheld in court. If a file was named a name that suggested some sort of illegal activity, then based on this precedent and another precedent in a different state, then that would possibly be fair game. for investigation without a warrant. That is my presentation and forensic case study. My name is Chelsea West, and thank you for listening.